Don't make the announcement on time. That's how the place will be out there till justice will come in.
Kindly take your seats, please. Distinguished ladies and gentlemen. The ceremony is starting shortly. Please, can we all maintain an order of silence in the hall? Silence, please. Thank you, my Thank you, seniors.
Okay, yes. Yes. So I said.
Thank you, gentlemen. Thank you, distinguished leaders. Part of the protocol, they are part of the security details. If you do not have a seat, please you.
Don't worry, when I do this, thank you. Over there.
Huh? Okay. Yeah. Let it stand there. Okay, man of people.
As amended, that I will, to the best of my ability, assist the courts of justice duly established in the Federal Republic of Nigeria in the performance of their judicial functions, and that I will at all times uphold the dignity of the rank of the Senior Advocate of Nigeria. So help me God. Thank you.
That's it.
It gives me immense pleasure to welcome you all to the commencement of the 2025-2026 legal year of the Supreme Court of Nigeria. This occasion is always one of solemn reflection and renewed commitment to the noble calling of justice. It holds an even deeper significance for me personally, as it was on this very occasion last year, held on Monday, the 30th of September 2024, that I addressed you for the first time as the newly sworn-in substantive Chief Justice of Nigeria. Today, 1 year on, I return with gratitude for the journey so far, mindful of the immense responsibilities that the office continues to demand, and inspired by the progress we have collectively made as a judiciary. The legal year provides us with a unique opportunity, not merely to mark the passage of time, but to take stock, to reflect on our challenges and achievements, and to recommit ourselves to the ideals of justice, fairness, and service to the Nigerian people. It is a moment to acknowledge how far we have come and to chart the path for the work that lies ahead. Today's celebration and reflection is, however, tinged with a deep sense of loss. In the past legal year, our legal community was profoundly saddened by the passing of 4 of our esteemed retired justices, including a former Chief Justice of Nigeria. They are Honorable Justice Muhammadu Lawal Uwais, GCON, JSC retired, Honorable Justice Emmanuel Olayinka Ayola, CON, JSC retired, Honorable Justice Stanley Shenko Alagwa, OFR, JSC retired, and Honorable Justice Emmanuel Obioma Ogwegu, CON, JSC retired. The loss of these legal giants is a significant blow to the judiciary and the nation as a whole. Their contributions to development of our jurisprudence, their unwavering commitment to justice, and their exemplary service to the nation will be forever etched in the annals of our legal history. They served with distinction, leaving behind a legacy of landmark judgments and a profound impact on the legal landscape of Nigeria. On behalf of the Supreme Court and the entire Nigerian judiciary, I extend our deepest condolences to the families of the departed justices. We also lost some valuable members of staff. I equally extend my condolences to their families. May the souls of all the departed rest in peace. Amen. One of the key priorities of the judiciary has been to enhance the efficiency and effectiveness of our courts. The past legal year has been one of significant strides and notable achievements in our collective pursuit of a more efficient, accessible, and just legal system. We have diligently worked to uphold the principles of the Constitution and the rule of law, ensuring that justice is dispensed fairly and without fear or favor. Since the start of the last legal year, we have been making tremendous efforts to restore public confidence in the Nigerian judiciary. At the National Judicial Council, every pending petition against judicial officers was carefully reviewed with appropriate sanctions imposed on those found wanting. Cleansing the audience stables is a collective duty, and we remain committed to it. By the same token, where allegations against judicial officers were unsubstantiated, they have been publicly exonerated. Similarly, for the first time, the NJC has taken the decisive step of barring a notorious serial petitioner whose numerous petitions were consistently found to be frivolous and without merit from presenting further petitions before the Council. In the same vein, members of the bar who have been found wanting have been referred to the Legal Practitioners Disciplinary Committee for appropriate disciplinary action. We have continued to refine our case management systems to reduce delays and ensure the timely resolution of cases. This includes the implementation of stricter timelines for case filings and hearings, as well as the active monitoring of case progress by judicial officers. We have equally invested heavily in the training and development of our judicial officers and court staff. This includes continuous professional development programs, workshops, and seminars aimed at enhancing their knowledge, skills, and understanding of contemporary legal issues. We are working assiduously towards improving the physical infrastructure of the courts, such as the renovation of existing facilities and the provision of modern equipment and technology. A cornerstone of our reform efforts has been the computerization of court processes. We recognize that technology is essential for modernizing our judicial system and improving its efficiency. We have embarked on a comprehensive program to digitalize court records, making them easily accessible and searchable. This will not only improve efficiency, but also preserve our legal heritage. Upon my assumption of office as Acting Chief Justice in August 2024, a special committee was constituted to recommend wide-ranging innovations to restructure and sanitize the litigation department of the Supreme Court and make court processes more accessible and less cumbersome. Acting on the recommendations received, a court records processing unit was created by merging process records and file units. This has drastically reduced incidents of missing files. A central information unit was subsequently established to provide lawyers and litigants with quick, convenient access to case details. A case continuation unit has also been created to ensure timely handling of adjourned matters. Let me use this opportunity to place it on record that the current practice in the Supreme Court is that dates for hearing of appeals are given during court proceedings, either in open court upon adjournments or based on a motion filed by parties, which may, where necessary, be considered in chambers. This procedure eliminates third-party interference that previously facilitated sharp practices. A robust tracking system now monitors file movement, virtually eradicating file losses. Additional reforms include digitization of receiving and data entry units and a reorganization of the registry to promote transparency, digitization of exhibits and judgment pasting units for the preservation of judicial records and enabling easy retrieval of past judgments. Creation of a disposal unit to archive concluded cases and transfer them to the National Archives. We have achieved full integration of the court's enrollment unit with the Nigerian Law School through an online platform for new lawyers. These measures have yielded positive results. In a bid to modernize service delivery and enhance operational efficiency from a manual paper-based application process to a more streamlined online application system, the new platform provides a faster, more convenient and user-friendly experience, unlike the previous manual system where applicants were required to submit documents physically or via email, which often resulted in delays, errors in entering data, and limited tracking capabilities. The new online application form has simplified the procedures by enabling applicants to create an application profile, complete and submit applications electronically, upload the required documents, track the status of their applications, and receive notifications and updates digitally. We have equally introduced the Electronic Notary Register, ENR, as the Supreme Court's official digital register for all certified notaries in Nigeria in compliance with the Notaries Public Act 2023. This will serve as a centralized and secure database that will ensure that only qualified and registered notaries are recognized to perform notary services. The register offers greater accuracy, security, and accessibility while maintaining compliance with applicable legal standards. It also provides a modern approach to record keeping that encourages transparency, efficiency, and accountability. Beyond technology and process reforms, we have prioritized staff welfare. Over the past year, incentives were introduced to boost morale and reinforce commitment to institutional goals. Salaries and allowances are paid promptly, and all existing welfare packages have been increased. The end-of-year welfare package was also significantly enhanced. Continuous staff development remains central to our mission. Targeted training programs have strengthened competence across departments, reduced registry errors, and improved service delivery. We have also nurtured a constructive relationship with the Judiciary Staff Union of Nigeria, JUSUN, addressing grievances proactively to maintain industrial harmony and prevent the disruptions created by past strikes. The Corruption and Financial Crimes Cases Trial Monitoring Committee, COTRIMCO, under the leadership of Honorable Justice Suleiman Galadima, CFR GSC retired, has demonstrated exemplary dedication in its mission to ensure the expeditious adjudication of corruption and financial crimes across the nation. Collaborating seamlessly with the country's various anti-graft agencies, COTRIMCO has been instrumental in accelerating the judicial process for all cases pertaining to corruption. The first and second quarters of 2025 have revealed remarkable progress. The Economic and Financial Crimes Commission, EFCC, successfully secured an impressive 1,417 convictions, underscoring their relentless pursuit of justice. Concurrently, the Independent Corrupt Practices and Other Related Offences Commission, ICPC, initiated 43 new cases and achieved 9 convictions, reflecting their continued efforts in combating illicit financial activities. It is particularly interesting to note that the ICPC has experienced a substantial decline in the volume of corruption and financial crime cases being prosecuted, a trend that has consequently led to fewer returns on cases. This positive development is primarily attributed to the proactive and preventive measures recently implemented by the Commission, signaling a strategic shift towards deterring such crimes before they escalate. It is noteworthy that the Supreme Court has continued to work assiduously to address the backlog of cases. In the 2024-2025 legal year, which ended on Friday, 18 July 2025, the Court considered a total of 2,280 matters comprising both motions and appeals. Of these, 1,720 were motions broken down into 1,025 civil, 488 criminal, and 27 Sharia-related matters. The Court also entertained 560 appeals broken down into 352 civil, 180 criminal, 6 political, 15 Sharia, and 7 originating summons. From these matters, a total of 369 judgments were delivered. The past legal year has been a testament to our unwavering commitment to the speedy dispensation of justice. The number of appeals disposed of reflects significant progress when compared with the preceding 2023-2024 legal year, during which the Court handled 1,124 cases, comprising 435 civil appeals, including 89 political appeals, 269 civil motions, 219 civil appeals, 102 criminal motions, and 10 originating summons. These culminated in 247 judgments and rulings. This positive improvement is the outcome of deliberate measures, including the adoption of innovative case management strategies, coupled with a strategic enhancement of judicial capacity. I take this opportunity to express profound appreciation to my esteemed brother justices of the Supreme Court, whose intellectual rigor and tireless dedication, together with the steadfast support of our indispensable support staff, have been the foundation of these accomplishments. As we commence this new legal year, we do so with renewed optimism and a firm resolve to build upon this strong foundation. With the continued cooperation of all stakeholders in the administration of justice, we remain committed to achieving even greater efficiency, deepening public confidence in the judiciary, and ensuring that the cause of justice is served with diligence, integrity, and fairness. The judiciary, especially at the subnational level, is often underfunded, which impacts its ability to function effectively. Inadequate funding leads to poor infrastructure, insufficient resources, and inadequate training for judicial staff and support staff. This, in turn, affects the efficiency and effectiveness of the judicial process. I need to state unequivocally that the challenges facing the judiciary are not the responsibilities of the judiciary alone. They require a collaborative effort involving all the 3 arms of government, the executive, the legislature, and the judiciary, as well as the active participation of the citizens. I therefore call on the executive arm of government, especially in the states, to provide adequate funding for the judiciary, improve judicial infrastructure, and support the implementation of technological advancements. I urge the legislature to enact laws that support the independence of the judiciary, strengthen anti-corruption mechanisms, and streamline court processes. However, it is heartwarming to note that despite these challenges, the Nigerian judiciary has made significant strides in the past year, and we are poised to sustain the momentum. Evidently, we are currently undergoing a transformative digital revolution with the progressive adoption of the Nigerian Case Management System, NCMS, an official nationwide platform meticulously developed under the discerning guidance of the NJC. This sophisticated system is designed to digitize the entire spectrum of case handling, thereby facilitating the seamless and instantaneous transmission of files from the litigation department of a particular state or jurisdiction, for instance, to the chief judge for judicious assignment to appropriate judges. This monumental undertaking involves the comprehensive uploading of all existing backlog cases within the respective courts into the NCMS, a strategic move to significantly curtail physical interactions and mitigate the pervasive issue of procedural delays that have historically plagued the judicial process. At the Supreme Court, we are transitioning from traditional manual filing processes to comprehensive e-filing system fully integrated with the NCMS. As part of this reform, a dedicated module is being developed to enable lawyers to upload backlog documents for existing appeals directly through the NCMS portal. Access will be obtained via a simple online case access request, subject to immediate review and approval by the designated Electronic Litigation Registrar, ELRP. This digital integration will significantly enhance the court's capacity to retrieve, track, and manage every aspect of an appeal, spanning from hearing to final disposition. To guide stakeholders, a practice direction outlining the onboarding process and application usage will be issued in due course ahead of the official launch. The pioneering state judiciaries that have already embraced this technological leap include Borno, Bayelsa, and Delta judiciaries, showcasing their commitment to judicial modernization. Concurrently, Niger and Taraba states are actively preparing for the imminent rollout of the NCMS, underscoring the broader national commitment to this pivotal digital transformation. These technological advancements are crucial for modernizing the judiciary and ensuring that it remains relevant in the 21st century. In the same spirit of progress, we also recognize that the strength of our judiciary rests not only on systems and structures, but equally on the quality of the men and women who serve within it. As we advance technologically, we must also continue to celebrate and nurture human excellence. It is against this backdrop that I extend my warmest congratulations to the 57 legal practitioners who have earned the esteemed rank of Senior Advocate of Nigeria. This recognition is a culmination of years of dedicated service, resolute commitment to the rule of law, and exceptional contributions to the legal profession. Among you, we are especially inspired by Mr. Lawal Hudu Garba, who, despite being physically challenged, has demonstrated extraordinary perseverance, dedication, and excellence in the practice of law. Your achievement is a powerful testament to the strength of human spirit, the triumph of talent over adversity, and the fact that determination and professionalism knows no bounds. Your achievements serve as an inspiration to us all, and I'm confident that each of you will continue to uphold the highest standards of legal practice and contribute to the advancement of justice in our nation. The conferment of this rank is a rigorous process, reflecting the high expectations placed upon those who bear the title. It signifies not only professional excellence, but also a commitment to ethical conduct and the upholding of the integrity of the legal profession. You have all actively participated in the pre-swearing-in induction program organized by the Body of Senior Advocates of Nigeria, BOSAN, where invaluable insights were shared with you. I urge you to uphold and internalize those principles so that you may carry this rank with the utmost dignity, grace, and sense of responsibility it demands. Let me take a moment to reiterate a caution I delivered at last year's ceremony. The rank of Senior Advocate of Nigeria is a privilege, not a right. The privilege can, and indeed will, be withdrawn in appropriate circumstances where it is abused. I commend the efforts of the Legal Practitioners Privileges Committee in sustaining the standards and integrity of the process leading to the final selection of successful applicants. The Judiciary remains steadfast in its constitutional role of dispensing justice fairly and impartially. We will continue to work tirelessly to improve the efficiency and effectiveness of the judicial process, uphold the rule of law, and protect the rights and freedoms of all Nigerians. Yet, this mission cannot be achieved without the unwavering commitment of our judges and judicial staff. I urge us all, as custodians of justice, to carry out our duties with integrity, discipline, and diligence, always remembering that the nation's trust rests upon our shoulders. Let us eschew every act of indolence, delay, or compromise, and instead embody the highest ideals of service, humility, and devotion to the Constitution. To our citizens, I call upon you to uphold the rule of law, respect the decisions of the courts, and report any instances of corruption or misconduct within the judiciary to the appropriate institution. Together, we can build a judiciary that truly inspires confidence, strengthens democracy, and secures a more just and prosperous Nigeria for generations to come. I wish to sincerely thank all who took the time to grace this special occasion, heralding our new legal year. We are very grateful for your presence despite your busy schedules. I also wish to express my gratitude to the Honorable Minister of Justice and Attorney General of the Federation, Prince Lateef Fagbemi, Senior Advocate of Nigeria, the Chairman of the Body of Senior Advocates of Nigeria, Professor Alfred Bandele Kasumu, Senior Advocate of Nigeria, who is ably represented here, the President of the Nigerian Bar Association, Mazi Alpha Mosigwe, Senior Advocate of Nigeria, and the spokesperson for the newly conferred Senior Advocates of Nigeria, Mr. Theophilus Eson Kolawole, Senior Advocate of Nigeria, for actively participating in and contributing to the success of this ceremony. I thank you all for honoring our invitation. May all
made in the course of nation building over the years, and particularly in the past legal year. The Supreme Court has continued to assert itself through its fair judicial interventions in strengthening constitutionalism, deepening our democratic governance and rule of law. It is also my honor to specially congratulate my noble lord, the Honorable the Chief Justice of Nigeria, Honorable Justice Kudirat M. Okekere-Ekun, GCON, for competently steering the ship of the Nigerian judiciary in the past year since your lordship's confirmation by the Nigerian Senate and swearing in as the 23rd Chief Justice of Nigeria by His Excellency President Bola Ahmed Tinubu, GCFR, on the 30th day of September 2024. I am delighted to note that within a short span in the saddle, your lordship has demonstrated capacity, courage, and commitment to enabling the much-needed judicial reforms, which include strengthening judicial integrity, reforming case management in the Supreme Court, responding to concerns about conflicting decisions, taking a firm stance on the menace of legal practitioners who pay scant regard to the principles of sub judice by engaging in media trial, deepening digitization of the judicial processes, tightening discipline of both the bar and the bench, and enforcing the new Supreme Court rules. I commend your lordships for the landmark decisions rendered in the outgone legal year. These decisions resonated across the Federation while strengthening our constitutional democracy. I specifically recall your lordships' landmark decision of 15th November 2024 in the matter of Attorney General of Kogi State and Attorney General of the Federation, strengthened and sustained the fight against corruption by affirming the constitutionality of the establishment, laws, and prosecutorial powers of the Economic and Financial Crimes Commission, the Independent Corrupt Practices and Other Related Offences Commission, and the Nigerian Financial Intelligence Unit. In the same vein, your lordship on the 22nd of November 2024 rendered another landmark judgment in the matter of Attorney General of Lagos State and the Attorney General of the Federation, where this court nullified the National Lottery Act, establishing that the National Assembly lacks the constitutional power to legislate on lotteries, which is a residual matter for the Senate, for the state houses of assembly. Recently, the role of our judiciary in consolidating our democracy has aroused much public interest and discussions. It is a universal truism that the judiciary sustains the rule of law, which is the bedrock of our democracy. Over the years, the judiciary has increasingly been called upon to adjudicate on matters that strike at the heart of our democracy: electoral dispute, constitutional interpretation, protection of fundamental rights, and other legal or public policy matters. Yet, this rising responsibility has firmly placed the judiciary in the court of public opinion. It is quite concerning to see the adverse rating and negative perception indexes of our judiciary. Public confidence in the judiciary has been shaken by perceptions of undue influence, inconsistent rulings, and delays that frustrate justice. Allegations of corruption, though often unproven, cast long shadows. While I agree that the judiciary should be accountable less to public opinion and more to public interest, may I respectfully insist that in this climate, the judiciary should discharge that accountability by being principled, independent, and impartial. It must not only deliver justice, it must do so transparently, consistently, and with intellectual rigor. It is therefore the responsibility of everyone present here and beyond to ensure that, like Caesar's wife, the judiciary is above reproach and suspicion. I wholly adopt the admonition of my noble Lord, the Honorable Justice Kekereekun, JSC, as he then was, that the role of the court in the administration of justice provide a conducive atmosphere for both parties. Citation of the cases given by Babangana and others. My lords, the strength of a judiciary lies not in the volume of its judgment, but in their clarity, coherence, and courage. Let our judgments be written not only for lawyers, but for the citizens whose life shape to preserve the public trust and sustain the common man's last hope. I humbly pray that your lordship, the Honorable the Chief Justice of Nigeria, will cause ongoing reforms to gain momentum in the legal year. On my honor, I wish to affirm that my office remains committed to working with the judiciary and other stakeholders in the justice sector to advance reforms that will elevate the standard of justice delivery in Nigeria. I support the ongoing administrative and legislative interventions, which include strategic and consistent capacity building, strengthening institutional safeguards for judicial independence, and case management reforms to reduce delays and improve access to justice. Your lordships, I must emphasize that at this juncture, the operations and proceedings of the Supreme Court ought to have become fully digitized and automated. I respectfully urge the National Judicial Council and the various heads of court to accord the topmost priority to the full deployment of technology in the running of our courts to enhance case management. While our quest for judicial reform is not limited to infrastructure, digitization, and procedural efficiency, The reform must extend to our legal philosophy and culture, how we conceive, pursue, and achieve justice. It is our binding duty to continue to evolve a legal system that serves a modern and informed society. To all the 57 new silks, I offer my warmest congratulations and welcome you to the elite advocacy corps of the legal profession in Nigeria. You have earned this honor through years of excellence and integrity. But with this rank comes a solemn duty to be architects of reform, defenders of judicial clarity, and mentors in the art of legal reasoning. In entering this profession and on being further admitted to the inner bar, with all the privileges attached to the status, we become ambassadors of the finest tradition of Africa's largest bar. I am aware that the body of senior advocates of Nigeria has taken you through an advanced pupillage session. I wish to add that your rank confers additional responsibilities on you. You must not only be occupied with navigating statutes and judicial precedents, but you must also deliberately concern yourself with upholding ethical standards, professional excellence, and best practices to sustain the public trust in the profession. You are required to always toe the path of honor and justice as ambassadors of the legal profession. Let your advocacy and legacy be measured not only by victories, but by the depth of thoughts you bring to the law and the integrity of your legal practice, defense of the judiciary, and protection of the rule of law. Our rules of professional conduct and our calling as noble men must be our holy grail. They must guide our faithful observance of the solemn oath which the newly learned souls have just taken. Higher standards that ennoble the exalted rank are expected of you, and the departure must be visited with appropriate sanction. I cannot stress enough that our duty transcends what we do in court. As counsel for client, it extends to how we conduct ourselves among colleagues outside the courtroom or in a foreign land. You must bear in mind that senior advocates of Nigeria are not just legal practitioners. They are not just ministers in the temple of justice. All lawyers bear that burden as well. But you, learned souls, bear more as professional brand carriers of the highest distinction. Hence, we must keep a wide berth from the littlest of infamous conduct, that is conduct as held in the case of MPP and Okonkwo, citation given, regarded as disgraceful or dishonorable by our professional brethren of good repute and competency, and by being conscious that its meaning encompasses not just the literal interpretation of our code of ethics, but its spirit also. We cannot defame our calling and be flattering ourselves as silks. We must be above board. The Nigerian public and the world at large rightly expect and will judge us by our conduct both within and outside the courtrooms, and also by how steep a price we are made to pay when we fall short to deter and demarcate the pollutant and bad eggs amongst our ranks. Lastly on this, let me share a Yoruba proverb with you, underscoring the special nature of reproach as a picky guest and admonishing those who live in ivory towers. It goes thus, quote, Tí àbùkù bá jí láàárọ̀, ilé ẹni tó lórúkọ ló ń lọ àbí ló ń wá. Meaning, when disgrace or reproach wakes up in the morning, it heads for the home of a person who has reputation. As well as we all know, the rank of senior advocate of Nigeria is a reputable one. We must do our utmost to guard it jealously. This brings me to a matter that should be of concern to all of us. My office has in recent times taken note of increasing number of complaints against senior members of the bar. Thankfully, these are few and far between. and they still constitute such numbers as to be troubling. The complaints border on professional misconduct and, if not addressed urgently, are capable of bringing the prestigious rank into disrepute locally and, as we have seen recently, internationally. We need to reverse the perception that the rank of Senior Advocate of Nigeria confers immunity from disciplinary measures for professional misconduct. We simply cannot have a bar where one law applies to the juniors and another to seniors. My lords, distinguished ladies and gentlemen, of note is the topical and trending matter that recently struck at the standing of our profession in Nigeria, in the eyes of the world and in a way that stands out in recent memories. It bears sadly on the high esteem and the integrity that our noble profession commands as a sine qua non for our collective commitment and investment in the legal brand. I am referring to the recent decision of 11 September 2025 of an English property tribunal by Judge Ewan Patton. It will be remiss of me not to bring such an egregious development to the attention of my lords in the hope that it is addressed frontally against the backdrop of the hallowed rules that guard and define the finest tradition by which our nobility should be measured. It is for this reason that my office has now taken the unusual step of verifying the authenticity of these and other complaints with a view to referring them to the appropriate disciplinary bodies. I look forward to receiving the appropriate cooperation of the Nigerian Bar Association and the body of Senior Advocate of Nigeria in this regard. My lords, learned colleagues, distinguished guests, I wish to remark that today's ceremony is not only marking the beginning of a new legal year or celebration of excellence in the legal search and advocacy, but also a moment of reflection, a time to examine the state of our administration of justice system and to renew our collective commitment to its reform and advancement. The Federal Ministry of Justice under my watch in the previous legal year intensified our efforts at achieving a justice system that works in the interest of all Nigerians, irrespective of their economic status, gender, ethnic origin, or any other attribute. We continue to play a central role in shaping Nigeria's overall justice framework. An immediate outcome of the National Summit on Justice we convened in 2024 was the adoption of the National Justice Policy as a framework for driving constitutional, statutory, and institutional reforms of the justice sector. Our overreaching vision for justice sector reform involves reforming our legal system to align with the values in the 1999 Constitution, enhancing access to justice, particularly for those who come in conflict with the law, and enabling our ability to deliver professional legal services to the government and people of Nigeria through capacity building of the human resources and encouraging the use of technology in our service delivery. Ultimately, our interventions have been about strengthening the public trust in the justice sector. To achieve these in concrete terms, we have taken a number of activities. We recognize that sustainable justice sector reform can only be achieved where the federal and state governments work collaboratively. My office has therefore deliberately engaged the state attorneys general in our major interventions in the justice sector. Specifically, the area of criminal justice administration. In the area of criminal justice administration, we are working with the state ministries of justice to reverse the unacceptable high number of persons on remand in our custodial centers nationwide. The Federal Ministry of Justice Working Group on the status of persons in Nigeria's custodial centers have provided baseline research to enable joint action by the federal and state governments on the issue of discongesting our custodial facilities. We also recognize the importance of partnerships with the state governments in the review of the laws of the Federation. It is gratifying that most of our states have been inspired by the determination of the federal government of Nigeria to update the laws of the Federation and are now at various stages of the review of their laws. I am also happy to report that the Fakunda Committee on the review of the laws of the Federation has made rapid progress on its assignment. The committee is now at the final stage of completing a review of the 1,509 acts and subsidiary legislations that are subject of its assignment. In the new legal year, we will consolidate our achievements of the past year. The National Justice Policy is a vision that we have committed ourselves to implementing over the next 2 years and beyond. We will continue to develop and maintain an efficient system for administering justice and state legal affairs. This will be keeping with the ideals expressed in the renewed hope agenda of our dear President Bola Ahmed Tinubu, GCFR, such as promote fair and equitable access to justice for all, provide legal services to the government that are efficient and cost-effective, provide career advancement possibilities for all those who work in the Federal Ministry of Justice, and ensuring that agencies and institutions that are supervised by the Federal Ministry of Justice have enough personnel with the right kind of skills, knowledge, and resources to enable them deliver on their mandates. My Lord, distinguished ladies and gentlemen, to conclude, I would like to state that as an institution, the Federal Ministry of Justice will remain open to working with all institutions that share the goals and ideals of enhancing access to justice and the rule of law. And in this regard, I would like to acknowledge all the local and foreign institutions that engaged with the Federal Ministry of Justice in the past legal year. I should also place on record my gratitude to my hard-working colleagues in the Federal Ministry of Justice who continue to work beyond the call of duty despite our institutional challenges. It is now left for me to wish your lordships renewed will and strength of purpose for a most successful legal year. I wish the new silks a most fulfilling sojourn at the inner bar, and finally, I wish all members of the inner and outer bar a happy new legal year. I pray for our good health and success, and that we remain guided to the righteous path, to which I quote a worthy verse from the Holy Quran. It is 1:6. All it says is, guide us to the straight path. Amen. My lords, your excellencies, distinguished ladies and gentlemen, and dear colleagues, I thank you for listening, and may God bless the Federal Republic of Nigeria. Thank you.
Thank you very much, Attorney General.
Today, on behalf of my set of newly conferred senior advocates of Nigeria, with a heart full of gratitude, humility, and deep reflection, to God be the glory. For me, this honor is a combination of 43 years of service at the bar, years in which I've witnessed both the triumphs and the trials of our profession. I entered this noble calling at a very different era. Legal practice of the early 1980s was one where resources were scarce, where access to justice was limited, and where cases sometimes moved at a painfully slow pace. Yet I also remember the deep reverence with which the courts were held and the sense of dignity and service that drew us to this profession. Over the decades, we have seen our legal system grow. We have seen the bar become more vibrant, more diverse, and more sophisticated. We have seen the bench, against tremendous odds, deliver judgments that have not only shaped our jurisprudence, but also strengthened our democracy. From the early struggles of access and delay, we now see a judiciary that commands respect within and beyond our shores. Our jurisprudence is richer, our institutions stronger, and our collective resolve more enduring. In reverence, we must pause to acknowledge the current Chief Justice of Nigeria, His Lordship Honorable Justice Akpoti-Uduaghan, GCON. My Lord, under your stewardship, the Judiciary continues to bear the heavy responsibility of safeguarding the rule of law in our country. Your Lordship leadership has provided direction at a time our democracy requires stability and confidence. We must also acknowledge the Honorable Attorney General of the Federation, Prince Lateef Fagbemi, SYN, who bears the constitutional responsibility of balancing the interests of justice, governance, and the people. My Lord, the collaboration between the bar and the Office of the Attorney General remains crucial in ensuring that the promise of justice is kept alive for every Nigerian. I must personally acknowledge the tremendous role in becoming a senior advocate of Nigeria. Let me also publicly acknowledge my Lord and Justice Helen Ogumi PSC, who at SYMFONI State in 2024 gave me matching order to apply for what today I am celebrating. I thank His Lordship. Permit me, my Lord, to speak also from depth of personal memory. As I stand here today, my mind goes back to my late justice delayed is in fact justice denied. The workload of cases, working days sometimes peak alarmingly at between 20 and 25, if not more. It is therefore our hope and indeed our earnest appeal that we shall see in the near future an expansion of the appellate courts through the timely appointment of more justices and creation of more divisions, especially of the Court of Appeal, which is not only ease the burden on our courts, but also restore confidence in the efficiency of our legal system. As we, the newly elevated senior advocates, take this rank, we do so not in triumphalism, but in sober reflection. This rank is not an end, as we have been told, but a beginning, a call to higher responsibility, to deeper service, and to unwavering fidelity to the rule of law. We understand that to wear this seal is to carry the weight of history, the expectation of the public, and the solemn duty to ensure that justice is preserved. On behalf of my colleagues, I express our deepest gratitude to the Legal Practitioners Privileges Committee for finding us worthy of this recognition, to our mentors, teachers, and leaders of the bar and the bench who have guided us, to our families whose sacrifices are woven into every step of our journey to our clients, to our clients who entrust us with their cases, and above all, to Almighty God who has sustained us through the years. May this day inspire us not only to honor those who came before us, but also to leave behind the legacy of.
With the kind permission of my Lord, the Honorable Chief Justice of Nigeria, President for Justices and special guest only to be served at the Justice Entrance Foyer, while refreshment for the invited guest is served at the main court entrance to the Supreme Court. Court shall rise.
I take this.
Nice.